Good morning. My name is Sid Moore. I am the Interim Executive Director of the Psychiatric Security Review Board. And first of all, want to let you know how much we appreciate you all being here and all the work that you do out in the community. This is obviously an extremely important topic, and we're really happy to be able to provide some extra knowledge, some extra training for you. So if and if you want, if you have questions while I'm talking, just jump in. This is something that I'm very comfortable with. I can always get back to what I was talking about. I have the PowerPoint after all, so that shouldn't be a problem. But I'm going to try to keep my part of it relatively short because we have our outstanding panel here. Dr. Mohandessi is joining us on my right, and Katrina Bennett from Cascadia is Katrina. She's not the one who's not Dr. Mohandessi. So as you have questions, if you have questions for the panel, they will also be mic'd. I'll ask you to speak up with your questions, and I will try to remember to repeat because we are being recorded, and also because if you're behind the person who asked the question, you will not hear the question. Also, one other thing, I'm a little under the weather right now. I'm going to get through this. It'll be fine, but I'm normally a little sharper than this, just a little. Okay, so any questions before we start? All right, well, let's jump in. Anything from the panel? Anything you want to add? Anything I've forgotten? No. Okay, so again, Sid Moore, and then here's what I have to tell you. If I see, I normally turn on the slide advancer too. There we go. Still me. Okay, so what we do generally is, the main part of what we do is we supervise those who have been found guilty except for insanity. We have other things under us that I'll get to in later slides, but that is kind of the bulk of what we do. And if you encounter somebody who knows us a bit, that's what they'll be able to tell you. By the way, I need to jump back on a housekeeping thing. If you need to get up and leave at any point, that's fine. Please feel free to do that. Maybe go behind the camera though, if you don't mind. There is a lot of room back there, but then you're not kind of walking through the picture. So just, unless you want to be a TV star or something. So this is when we have people who are with mental illness who commit crimes. Most of the time in this country, they go through some semblance of the correction system. There are a few states in the union that have psychiatric security review boards. There are only two that work the way we do. One other that works the way we do, and that is in Connecticut. And so there are a couple of others, Arizona, and I think there's a new one somewhere in the Deep South. I'm not sure about that, but Arizona's works more like corrections than it does like what we do. So no matter, and that second bullet there about you being a critical piece, that's addressed to everyone in here. You're a critical piece of this puzzle, regardless of what you actually do within the mental health system, within the legal system. Otherwise, you wouldn't be here. And so we're a very tiny agency, and so we need community involvement in order to do what we do. And so we depend on those partnerships, and we value those partnerships. I'm going to try to move around a little bit because sometimes I'm blocking the screen from some of you, and I'll just try not to block it from everybody. So there are a number of misconceptions out there about the PSRB. I get where a lot of those come from, but it doesn't change the fact that some of those things that people believe are true aren't true, and some of them possibly used to be true and are not anymore. So I'll ask you for a little audience participation. I'm sorry I did not warn you about that, but what have you heard about the PSRB? What do you know about it, or what do you think you know about it? That one was you have to commit a heinous crime and be found guilty to be under the PSRB. We do have we have only felons under us, and we'll get to kind of the breakdown of which felonies and so forth in a later slide. But that part is correct. The thing to remember is that guilty except for insanity is what we call the bulk of our population. They've been found guilty except for insanity, but that's an excuse. So they haven't actually been convicted. So that's really important to remember, because sometimes what gets said is, well, this person, you'll see it in the newspaper, and and this is kind of, there are only 2 PSRBs, as I said, in the country, and so the press isn't necessarily used to writing about us, but it's guilty except for insanity. So the person lacked the mental state to appreciate the consequences of their conduct or the illegality of their conduct. Anything else? Yes.
Your decisions about patient supervision is much more heavily weighted with concern for community safety than it is for clinical therapeutic value.
Mm-hmm. Well, yes, and both of those things are concerns of ours, right? Our statutory mandate, though, is to protect the public. Okay, if you look up the statutes pertaining to us, that's what it says. But one of the other things that is true is that a stable patient, you'll hear me say patient or client, we'll use them interchangeably, a stable PSRB patient who's engaged in his or her treatment is the safest kind of patient. So the mental health aspect of this is vital to what we do. If we don't have that, then we're not able to fulfill our statutory mandate. So, and remember too that the public includes everyone. It includes that includes the patient, him or herself, also. So that is something to remember. Anything else? Okay. So we have been around for just slightly over 40 years. 40 years and about 2 months. And so we were started because, as I said before, Oregon wanted to do something different, to have something that is treatment based, and recovery based, and those sorts of things, rather than to have the GEI population, sort of in more of a prison correctional kind of a situation. And so the 77 legislature created the PSRB and it became operational January 1st of 78. Okay, so what do I? By the way, do I have any lawyers in? Okay, I've got a couple of. Okay. So for the JD impaired. There are going to be some things in here. Sometimes I'll cite a statute, but it's going to be little and in the fine print, because that's what makes us feel at home as lawyers, right? Is the fine print. So just as we go through this, I'll be talking to you also, but mostly it's sort of the mental health community that we're talking to. So just because a person has a mental illness and commits an offense does not necessarily mean that they are GEI appropriate, right? It's the idea is that the illness has caused the person to commit the offense, right? So it's just like any other thing that you may have a chronic condition of any kind, but it doesn't necessarily cause you to to perform X behavior or Y behavior. So they have to be related. And so the other thing to remember too is we include county mental health in GEI cases, especially if you can read that bullet. A court conditional release we'll talk about it. Well, I'll talk about it now. That's when the court decides that the person is appropriate for guilty except for insanity, but instead of committing them to the state hospital first, sends them directly into the community. And about 70% of our patients are living in the community. About 30% are at the Oregon State Hospital. And so then the other thing too is that anytime you have a question for us, anytime you have a question about the GEI population, our civil commits, gun relief, whatever, which I'll get to in a little bit, please feel free to give us a call. Get on our website. We're updating the website all the time, and if you don't find what you need, feel free to give us a call and ask us. So for the attorneys in the room, if you're criminal defense attorneys and you are considering you have a client you're considering a GEI plea for, there are steps to go through. There are evaluations that have to happen, and our website can guide you as well as our staff. So our staff knows this stuff really well, and sometimes there's a complex question we have to get back to you, but that's okay. We will do that. We'll research that and get back to you. So this is not the front page of our webpage. This is the resources guide. So there's so once you get to the home page, at this point it's about a third of the way down the screen to the right. There's a resources tab, and if you click on that, it sends you here. And so we've got these resources categorized into what types of people are looking for them. So if you're an attorney or a judge, there's a tab for you, managers and staff. There's also a tab for that. Okay. By the way, sometimes I get to information before I get to my slide. So anybody remember the when of us? 40 years, 1978. So, and really the why then, we also covered the sort of the why now. We have quite a network of community providers. We work very, very closely with the state hospital. We work with law enforcement. We've been doing this a while now, and we've had a lot of opportunity for process improvement. That's not to say that there isn't still opportunity for process improvement, but at this point, the GEI population, that process, it tends to be relatively smooth. That doesn't mean that sometimes we don't have something that happens that is maybe a case of first impression or something we haven't seen in 10 years or something like that. But by and large, we have the system in place, and we're trying to make sure that patients are at an appropriate level of care, and that's why it's really important that we've had that since about 2010-ish. Jane here is our executive assistant, and she has been with the board a long time. So correct me if I'm wrong, but since about like 2010, 2011, we have seen more growth in community resources, and so we're able to have more of our patients in the community because we have those treatment levels. We have various treatment levels available in the community, so we're not having to keep patients in the hospital. We can have them out on conditional release more often. So any questions while I take another drink of water? Okay. Okay. This was, of course, alluded to a second ago. It is our primary purpose. That is a statutory mandate. Again, protecting the public does not necessarily mean putting every single person in the state hospital, clearly. So, and again, I got a little ahead of myself earlier and kind of gave away the bottom of this slide, but that's okay. We can live with that. So this is what we look like. So you'll see a lot of twos there, and that basically means that we have part of our board. Half of our board is deals with our juvenile population, which at this point is in the neighborhood of about 10 patients. I think we might be back up to 10. We were down to 8 for a little bit. And then the other board is the other panel is the adult panel. So it's one from each category for adults and one for juveniles. And the weekly hearings tab that refers to the adult panel. They meet basically weekly, probably about 3 times a month usually. And the juvenile panel meets about once a month to once every 6 weeks, because again, when we have so few patients, so few juvenile patients that their hearings don't come up as often. With a census of about a little over 500 adult patients, obviously their hearings will come up. Most of their hearings though are administrative in nature, and so they review the record, and then they decide. Can we move this client to a higher level of? Do we need to move this client to a higher level of care or to a lower level? Those sorts of things. Can they get driving privileges, for example, which is something that our patients can ask for once they've been on conditional release. Several of our patients anyway, they work and so forth, and so it's easier for them to get around if they have a driver's license. After a while of treatment and recovery and so forth, when it's appropriate, the case manager might ask the board if it's okay for the client to drive. Yes. No, that's a good question. Thank you for asking that. Once a person is placed under if they're a juvenile, they remain under the juvenile piece. They don't transition to the adult, although they can if they've been committed as a juvenile when they turn 18, and if it's still appropriate for them to be committed, they'll transfer to the Oregon State Hospital, but they'll still be under the juvenile board. Yeah, thank you for asking that. So when we talk about hearings, most of them are administrative, but for those that are live, where it's sort of like it kind of looks like a trial. Any 3 of the 5 panel members will sit at a time, and so the patient may see a different group of 3 each time he or she sits before the board. But those hearings are open to the public. They occur at the state hospital in the hearings room or in our office downtown. Oh, yes. Sorry. Question was, well, okay, got a little close there. Sorry. The question was how many attorneys do we have representing PSRB clients? Well, about 90% of our clients are represented by the same attorney. And then Marion County public defenders have sort of the remaining 10%. So how many actual attorneys they have, I don't know exactly. I don't know exactly. But it's 90% one attorney and then 10% Marion County. Yes. What would it be, about 452-ish, something like that. And there's my phone. So, yes, Jane. Right, thank you. And and Jane said that youth are represented by Youth Rights and Justice. I'm going to turn the ringer off on my phone. Normally, it's very important that it be on, because, we get emergency calls from time to time, but right now it's not appropriate. So I apologize for not doing this before. And my personal phone is always on vibrate because, frankly, it kind of annoys me. So so anyway, so that's kind of the answer to the attorney question. Yes. Yes. Mhm.
So I maybe should take a step back because
Okay.
she asked the question about how many attorneys there are for the PSRB, and I was thinking from a standpoint of the consumer who would have a like a defender or his own attorney for that first part. So so once they meet this criteria, then there are attorneys that would represent them going forward. I guess that's my understanding.
Right. Yeah. So then the question about how many attorneys there are representing PSRB patients. My answer was with respect to people who've already been placed under us. We don't control who gets placed under us. The court, it comes through the court, usually by via a plea. Every so often, a contested case will result in a jury finding of guilty except for insanity. So, the patient may have there could be as many attorneys as there are patients on the way in the court system. But most of our patients are indigent, and so they're represented by the attorney who has the contract for indigent defense. So once they're under us, of those 500 or so people, that's most of them are represented by that one attorney.
I have a quick question about,
Yes.
so you mentioned that you aren't in charge of who you are eventually placed into your jurisdiction, but I guess my issue is that maybe there's a little leeway in that because let's say a jury finds somebody guilty except for insanity of a crime,
Mm-hmm.
and then let's say drugs are also involved, including mental health, and then they could go to the PSRB, be determined not to be under your jurisdiction because drugs maybe were a big factor, and then
Mm-hmm.
that person walks scot-free without a conviction, without supervision, without paying restitution, and and so that makes me really nervous as an attorney because I think it promotes people who malinger, or this is a way to get through the system scot-free if I just fake this mental illness.
Right. Okay. So then that question, that there was a lot to it. So I'm gonna no, it's okay. That's okay. I'm apologizing ahead of time if I don't get it exactly right. So please let me know. But basically, the question amounts to what about what's called malingering? So faking a mental illness to get a certain outcome, and that maybe the statutory structure might give incentives to people to malinger because it is true. Is that a fair summary? Okay, so it is true that that once a person is found guilty except for insanity, again, they haven't been convicted, and they're not going to be tried again because double jeopardy would certainly have attached. So they haven't been convicted. They get placed under us, and then sometimes the board discharges. And I have a slide on that. Sometimes the board discharges a person early. And basically when people are placed under us, they remain under us as long as they have a qualifying mental disorder, and that mental disorder makes them dangerous. And it has to be both. It's important to remember that it's got to be both. So at some point, if the person is determined either no longer to have a mental illness, or in the case of malingering, never to have had a mental illness, then they would be discharged for no qualifying mental disorder. It used to be mental disease or defect. You might have heard that phrase, but that changed in January. Or if they're no longer dangerous, regardless of how severe their mental illness is, and this happens where the person's infirm a lot of the time. They can't ambulate. They would be dangerous if they could get up and chase someone down, but they can't do that, and so they're incapable of hurting anybody at that point. So and I'll come back to your question in just a second. So does that happen? Does malingering happen? Yes, it happens. I'd be lying if I said it didn't. But does it? Do we have safeguards in place to hopefully catch that beforehand? Yes. This is why This is why I want to say, was the certified evaluator was 2012, 2011. So there used to be, or well, now there has to be a certified evaluator, of an evaluation by a certified evaluator in order to successfully plead GEI. Could it still get missed? Yes, but the certified evaluators though are specifically trained in forensics. Right? So this is not just somebody who does treatment. This is somebody whose job it is to find this out. So yes, that does happen. The flip side though of the person, maybe being placed under arrest for 20 years and then being found no longer to have a qualifying mental disorder after 6 and being out from under arrest, that happens. Doesn't happen all the time, but the flip side of that is that for our patients who serve their time under us, they would have been out of, if they'd gone to prison, they would have been out before they get out from under us. So yeah, does it happen? Yes, because it's not a perfect system. We are trying, as I said, we always try to get better. But mental illness also is not like a lot of it's, if you have a physical injury, right? If you have a broken leg, any radiologist or a radiology student can read that X-ray and tell you whether your leg has healed or not. It's not the same with mental illness. So yes, it happens, and sometimes and the drug, and you did ask about drug-induced issues too. So when the psychosis is induced by drugs, then that's not an appropriate GEI. And so the trouble is that sometimes sometimes when there are drugs present and there's mental illness, and sometimes the mental illness really was the cause. Every so often, for one reason or another, the drugs were the cause. And if the court or the jury misses that one way or the other, then the person ends up in the wrong place. So you could potentially end up with somebody under us who it turns out ends up being discharged because it's later found that it was drug induced and they should have been in prison. But then the flip side is not great either, where you have somebody who really has a qualifying mental disorder, who really belongs in treatment, and for whom prison is doing no good whatsoever, but they end up in prison anyway. That's the flip side. So yes. Right. The question was, the standard is when they're no longer dangerous to others, that's when they'd be discharged, as opposed to being a danger to themselves, which is under the civil commitment.
Sid, can I ask just a minute here to
Sorry.
respond to your question as well? Thank you. So I'm a psychiatrist at Cascade Behavioral Health Care, and I've been in the role to treat patients in our PSRB program for 9 years. I also work privately doing these evaluations for competency and GEI. So the question that you ask is framed, in my understanding, as the front door problem. So the PSRB is not the gatekeeper to the front door. That is local jurisdictions and local trial proceedings that get people into the system. And yes, the concern about substance-induced disorders or malingering psychosis is always present. However, from my experience, because of this training that's been in place for over 7 years, we're becoming much better at detecting those bad actors. In terms of being discharged while under the board, it's not as easy as it may seem. I think people have a misconception in the community, either as attorneys or community individuals, that once someone's put under the board or found as GEI, spend a few months in the state hospital and then they're discharged either to the community or discharged outright. And that is very uncommon. Generally speaking, once adjudicated, individuals will fulfill their full commitment under the board, unless there is some extenuating circumstance.
I'd like to add one thing too, just To speak to, so the two criteria that someone could be discharged would be the jurisdictional discharge, which has to do with qualifying diagnosis, and then the other piece, which is the nexus of dangerousness. And the one element about that that's very different from any kind of civil commitment that's important is that it's not, is this person dangerous currently? It is, if this person's symptoms were to become active the way they were at the time of their instant offense, which is the offense that places them under the board, would that person then be dangerous? And so that's a very, very high bar. That's a very difficult thing to be able to prove, that if this person didn't have services, excuse me, and if the symptoms of their illness were active, would they be safe in the community setting? So it's a very different bar than the commitment bar on the civil side.
And I'm sorry for forgetting to say that. Thank you very much, both of you. Go ahead.
And one more point, maybe the audience can help us here. I mean, what are conditions that are excluded from commitment? What are the exclusionary criteria, let's say, for GEI?
So what? Right.
Correct. So substance-induced disorders, which will clear, obviously. There's no underlying major psychiatric diagnosis. Personality disorders, including ASPD or antisocial personality disorder, psychopathy. And under the current interpretation of the statute, it also does include paraphilias. So if it's purely a paraphilic disorder and no other major psychiatric diagnosis that was the nexus of the offense, then that individual is also not eligible for GEI.
For clarification, so then it is IED a diagnosis that can go through to the PSRB, correct?
As a primary diagnosis, developmental disability. Yes. Yeah. Yes. Sorry. So yes, we have several. We have plenty of clients who do have developmental disabilities. Oftentimes, they have other mental conditions as well. Anything else before I move on? Okay, I'm going to try to get through the rest of the slides fairly quickly because I want to give you more time with the panel. But this slide essentially amounts to everybody is a stakeholder. Right? That's what I could just as easily have put that up there. And something that Dr. Mohandessi just mentioned. I don't know how easy it is to read up there, but what it essentially shows is kind of what the public perception is of, when they ask these questions. 37% of people in the public said that the public said that about 37% of defendants plead GEI essentially, when the truth is it's less than 1%. So sometimes not only are these perceptions incorrect, they're wildly incorrect. So something to remember. And then I'll just point out C down there, months in confinement. Again, just what Dr. Mohandessi alluded to a second ago. That it tends to be more than the public thinks it is, and I think that my guess is that that the public thinks there's more malingering going on than there is. Again, it happens, but it isn't with the frequency that that people think it is. Now, having said that, when it happens and then people go out and commit other crimes, that does create more victims. It's not, and no one is happy about that. So I don't want to minimize the impact on the community for those things, but I want to make sure that people understand that that's not. It doesn't happen as much as a lot of the public thinks. So yes.
Back on the previous slide, it said months in confinement for insanity, equities, murder. So is that referred to the average length of stay when you say confinement, in the Oregon State Hospital or under PSRB jurisdiction? And is that something nationwide, or is that a statistic for Oregon?
That is that is in the hospital, and I believe this is national, if I recall correctly.
Do you think that would be consistent for Oregon as well?
The rest of the statistics on this kind of thing tend to be roughly the same, so my guess is that it is.
Lawyer question.
Sure.
On the chart, when it refers to insanity, acquittee, would that be, in our system, somebody found guilty except insanity?
Yes. Yes. Okay, so victim services normally sort of in the trial piece at the beginning. That's going to be a county function, but the victims of our patients' crimes can go through the State Department of Justice, and they have a specific an office specifically designed for victim services. So this was these numbers are actually from last September. We had about 511 as of January. I couldn't find the breakdown. I was out of the office most of the day sick yesterday, so that's when I would normally have found these stats so I could get them as make them as updated as possible. But that's basically what we look like right now. And so conditional release, those are people who are still under our jurisdiction, but who live in the community at various levels. So a secured residential treatment facility, an adult foster home, so forth, down to independent living. Some of our patients live on their own with roommates, with family. But that's what you're seeing there. And you can see after 2010, 2011, where we start to have more patients on conditional release or CR, that starts to go up at that point because again we have more community providers out there, more resources. There was also the State Hospital Review Panel, which came into being at that point because the idea was that PSRB wasn't putting enough patients on CR, so that came into being at that time. We now have such support in the community that the State Hospital Review Panel is actually going away in July, and those patients who there were tier 2 lesser crimes who were in the hospital, that's who the State Hospital Review Panel handled. They will all come back to us on July 1st. Okay, so this is what it looks like in the legal system. So for our attorneys, that's what you're looking for. But that's that gatekeeper function right there. Give you a chance to take a picture of it, write it down. Okay. So that's kind of how that happens, how people get to us. Okay. So it's the GEI is an affirmative defense. So the defendant has to plead it. Right. So that's the most important thing there. Well, actually, the most important thing is still the certified evaluator requirement. That's vital. And so if you're a criminal defense attorney and you're looking for a certified evaluator, these web pages we can get off forensic certification. It'll come up in a Google search. Okay. So obviously, some of this is duplicative, and I apologize for that. But really, must give notice to the court. It's not just a last second. Hey, now I'm gonna plead GEI. There's a lot that goes into it. Like you wouldn't want to try that, but it also won't work. A lot of preparation has to go into a GEI plea. The consequences either way are very high. And so that's kind of how it works. Oftentimes, or sometimes the court will send the person to OSH for the assessment. I promised I'd put some stuff in the fine print for you. So, yeah. And see, that one's just huge. Sorry for those of you, non-lawyers. I apologize for that statute being so large there. But this is what it is. If the person couldn't appreciate the criminality of the conduct, or they couldn't conform their conduct to the requirements of the law, so it's not just sort of this general I have a mental illness, and there's a specific thing that we're looking for, that the court is looking for in terms of a GEI. Okay, and this we talked about a second ago, right? That there can be the mental illness has to have caused the behavior. That's what's important to remember. That's pretty hard sometimes to unpack, though, right? Where does the mental illness end, and where is maybe there is some more intent? But with our population, many times what we've found is that when once properly treated and so forth, these are people who wouldn't have done what they did but for their mental illness. And occasionally you get somebody who, when they get treated, they get medicated, they don't necessarily remember what they did, or even if they do, they're kind of, they're hurt by it. They feel bad about it. This is not something that they don't have the same motivation as somebody who doesn't have a mental illness, which seems like it should be obvious, but given some of the public perception, it seems to me that it's not obvious to a fair amount of the public. So the person who kidnaps his or her kids because they're angry with their spouse, that's a totally different person from the person who ends up under us for kidnapping, because oftentimes there's a delusion involved in that kidnapping. It's not that I'm angry with my spouse or my ex-spouse. It's that I think that the police are going to take my kids, or the CIA is after them, or whatever. And so if you have that kind of delusion, then the decision to take your kids away from in that situation is rational, right? So it's a different thing. And that's important to remember. So some examples, which we, and we kind of had some negative examples earlier of like what is not a qualifying mental disorder, but most commonly what we see is some sort of schizophrenia or bipolar, and then there's DD, and right now I put the DSM-5 up there. It was relatively new, I forget when it was published exactly, but OSH started using it in about August of 2015, something like that. Once again, sometimes we get to stuff before we get to the slide. So drug-induced psychosis is the THARP case, obviously, and then the sexual disorders one that Dr. Mohandessi alluded to came from the Beiswinger case in 2004. So we obviously we have our statutes, but then we work under case law as well, just like any other agency. Okay. So here we have something. We have something sort of interesting, right? Sometimes we have a physical ailment, and either the physical ailment itself or the treatment for it plays havoc with the person's medication or otherwise with their treatment. So then the bottom here, the bottom bullet was the holding in the case. Okay, so drugs and alcohol, malingering goes back to your question. Then again, sometimes it's hard to unpack, but we do the court does what it can to unpack that, and then once the board sees it, they have to decide, based on the evidence, is this really a qualifying mental disorder, or is it not? And you'll note that the standard for being placed under PSRB is different from the standard for remaining under PSRB, because our board is dealing with what's going on right now. The court was dealing with the mental state at the time of the offense. Sure.
I think what I'm seeing defense attorneys make the difference between a lot now is like meth psychosis, which clearly doesn't qualify, versus long-term drug use that has actually caused a physical difference or a change in the brain or something like that. Does that qualify?
Yeah, that one's difficult. I'm going to give that to Dr. Mohandessi because that's really more of a medical question.
It's a difficult question, obviously, and it still is debated, and I don't think there's consensus on any specific answer. I think various jurisdictions may interpret it differently. What I do want to emphasize is that to remain under jurisdiction, it would qualify. And the forensic literature, medical literature have identified settled psychosis as a result of chronic or long-term substance use as a mental disease that does actually respond partially, if not fully, to psychiatric treatment. So when you're dealing with a case of settled psychosis, the front door issue is up for debate. When it comes to remaining under jurisdiction, it does count as a qualifying mental disease.
Okay, so I didn't underline must, but in your brains, as you look at this slide, underline must on this slide, right? If either of these prongs fails, then the board must discharge the patient. Okay, so it's not that's not discretionary. If the facts are that either of these things fails, then the board must discharge the person. Okay, so that's why you get people who, you know, if sometimes, you know, when they say, well, discharge with no supervision, that's true, but that was a legal requirement. Yes, Kevin.
I'm a fiduciary, and in this case, I was an emergency guardian for an old vet with not only PTSD but also schizophrenia and a number of who knows what else. But he had been going through this whole cycle almost, I think, 6 times from being charged with harassment and stalking and menacing in his community, then taken to the Lane County Jail, and the Lane County mental health guy tried to help, but he couldn't help, and so then he sent him to OSH, and they kept him, and they kept trying to do something and help him and stuff, and every time, like 6 times, he was judged to be unable to help with his defense, which in my opinion is, let's keep him, we can't go out, but then each time, they said, well, we can't help him anymore, and he doesn't want to be helped, so we're not letting him help. And it must have gone under one of these, but he would just go back and do the entire same thing again, then he ended up setting his house on fire. But it just was very frustrating to me because there was no one who could keep him under supervision.
And was that so? This is a question about a veteran who's had multiple contacts, at least with OSH. Am I getting that? Am I summarizing that correctly? So my understanding from your question was that this person was judged to be with the inability to aid and assist in his own defense. Okay, so in that case, and we have a slide on this later that I'll get to run through really quickly. In the cases of aid and assist, sometimes that's when the court has determined that the person is unable to assist in their own defense, and that it's a constitutional right to be able to do that. And so, a lot of times those patients get sent to OSH for treatment to try to help them get to the place where they are able to aid and assist in their own defense, and then but they don't have to be sent to the hospital. So what will happen is they'll go to the hospital. The hospital may say, well, this is all we can do for them, or, you know, in your case, in the case you're discussing, this person doesn't want to be here and we can't help them, but so they might be released from the hospital, but until they're able to aid and assist, then the trial can't go forward.
If I could, real quick, it sounds possible to me that may have been on the civil side and not on the PSRB side. Folks who have been placed under the board and are at OSH wouldn't be able to voluntarily leave if the hospital didn't feel like that was an appropriate option. Yeah, so there's a number of different populations at the hospital. It sounds to me like that was unlikely someone who was currently under the board. Although if they set a house on fire, they may have ended up there.
Yeah, that arson would be one of those felonies that under which people end up under us. Yeah, it's that is one of those things. Yeah. Yeah.
Does the board also have to discharge if somebody's met their statutory term of incarceration? And I understand that that's the case. If so, what happens if somebody, for instance, commits a crime that has a 10-year statutory maximum? At the end of that 10 years, they're still really dangerous.
Right.
What happens?
Well, so the question was, do people still come? Are they still discharged, released without supervision once they reach the end of their time under us? Well, what would happen if that person were sentenced to jail or to prison for 10 years? They would come out. So yes. So the answer is yes. If they have a 10-year time under us, then at the end of that 10 years we would discharge them. So what was?
I guess my question is, from a practical standpoint, what actually happens? I had a client like 25 years ago who was put in on a 10-year maximum, and my understanding is he's still at the state hospital because he can't get out. He's not safe to be let out. Do they do civil commitment?
Yeah, so if I could, certainly as a community provider, so I'm the clinical director at Cascadia for the PSRB program, and we have several times a year generally, because we have a very large program, somebody ending their jurisdiction under the board. So certainly as a community provider, not only are we working years in advance to prepare for that end of jurisdiction, but at the time of the end of jurisdiction, if we don't just walk away from somebody. So the community provider or those providing the mental health treatment will continue to provide services to that client if the client is voluntarily participating once they're not under the board. But also, we have a very good idea, like you said, somebody may still be dangerous. And at that point, at the time of the end of jurisdiction, it could be that we immediately start pursuing a civil commitment or a guardianship or some type of hospitalization if that person is symptomatic and appears dangerous.
Yes. Go ahead, Mickey. Okay. To everybody, Mickey Logan, legal director for the state hospital, that oftentimes sometimes there will be a civil commit, a 2-doctor civil commit hold if somebody has not been released from the hospital, has not been on conditional release, and they reach the end of their jurisdiction. Let's see, right here first, because I saw you earlier, and then yeah. Sorry, her, because she was in. Well, before. So sorry. So if let me try to summarize it, and we'll find out. So, how does somebody go from having a qualifying mental disorder to not? Okay. Well, I mean, these are the criteria. So I mean, it's whether the board feels like there's enough evidence to determine that whatever the person has isn't qualifying, or they don't have a mental disorder. I'm not 100% sure beyond what's here.
Maybe.
Right, and if I could, so the nexus of dangerousness piece, which is what I think you're asking about, right? So how do you guarantee that someone is not going to be dangerous in a scenario that you're not practicing, right? So if the person was not under the board and their symptoms were to become active, and as a community provider, we have clients they can request full discharge hearings with the board. Community providers are also able to request those if we believe that somebody might meet discharge criteria, and we're ethically obligated to do so at that point. So, for instance, if a client requests a full discharge hearing in front of the board, as a community provider, part of our role in that is to then determine whether or not we're going to support that request or not. And so looking at the nexus of dangerousness piece is something that we do a lot. There's a misconception that you can be discharged from under the board early for good behavior. It's kind of like you would in prison. And that's really not the case. People can be very, very successful under the board for years. They can follow all of the conditions of the release. They can be engaged in treatment. And that still doesn't speak to that nexus of dangerousness piece of it necessarily. So really what we're looking for, it's a difficult thing to gauge. And because of that, the bar is really high. And the piece that we're looking for is, over time, has this person demonstrated an ability to independently manage their mental illness? And what that looks like in a practical sense is, have we seen this person experience an increase in symptoms? When that occurred, was this person able to communicate that effectively to the team? Did they seek treatment? Are they independently engaging in their treatment in a real way, and are they able to do that even when they start to become symptomatic? So it's those kind of things that help us gauge not whether this person does well under the board. A lot of people do well under the board, but would this person continue to engage in things the way that they need to if they were not under the board in order to be safe in the community? The other thing, quickly, that we think about, and I know that the board weighs as well, is the person's psychiatric history, the history of their instant offense as well as other crimes that they may have committed, and certainly that weighs heavily in terms of nexus of dangerousness.
Thanks, Katrina. And again, earlier I said that it's not that this is not as precise, right? It's not. It's harder to unpack sometimes, but it's not guesswork fully either, right? There's a lot of evidence that goes through this. Okay, so then back here, and then here. So you sir, and then. I will confess that I know less about this about the never able to aid and assist, because we deal with the GEI and that sort of thing. But I'm going to ask. So I'm going to ask Mickey.
I could just respond quickly to that because it is part of my expertise as well. This does not relate to PSRB whatsoever. So let me clarify that first. But individuals that are found incompetent to stand trial, unable to aid and assist, are mandated to restoration treatment, which takes two major forms: medication to put their symptoms under control or remission, and restoration therapies, including judicial education and coaching, mock trials. And much of this is successfully done at the state hospital. And generally speaking, those found unable to aid and assist are returned to competency within 90 days. And then they are returned to the community through the jail system to then face the trial process. Sometimes at that point, the individual stops their medication and becomes sick again. Their symptoms then again cause them to be unable to aid and assist. And then that whole process may be reinitiated to the state hospital for stabilization and restitution. Now, in the case that individuals are found not able to aid and assist and are sent to the state hospital for evaluation and restoration, rarely, but there are instances where they are found to be never able to be restored. And that's generally due to organic process such as traumatic brain injury or a DD background. In those instances, medication necessity would be under the review of the hospital itself. They would go under a review hearing there to see if involuntary medication would put them back to competency. And in most cases, from my experience, the hospital does not find that involuntary medication is indicated. And so in that instance, they call the individual unrestorable, return them to the jail, and then they have to deal with the charge at that point. Nationally, what's known as cell orders are done in these situations. Oregon has incorporated that into our case law under LOPES. And these evaluations involve individuals that are refusing medication that would likely restore them to competency. And there are several criteria that need to be met to forcibly medicate them. From my experience using cell and LOPE criteria, for the most part, criteria are met, but there is one crucial criteria that can be argued against, and that is the last one. Does the state have a substantial interest in restoring competency to put the person to trial? If it is a minor offense, and if the person has already been under commitment in some form more than the maximum sentence of the offense, then one may argue that the state does not have a substantial interest to restoring competency. However, if the person has a serious offense and a serious criminal history, then the argument is more effectively made that the state does have a substantial interest at stake.
Okay, Deborah, sorry.
And if I could speak to that briefly, yeah, end of jurisdiction is really difficult. And for people who have been under the board for 10, 20, 30 plus years, it gets hard to imagine what it's going to be like to not have that entity dictating a large part of your life. And that's even for folks who have reached a point where they have demonstrated safety in the community enough to live independently, work full time, and all of that. There's a piece of, I think, knowing that entity is there that's hard to account for. It's hard to mimic that. As a community provider, certainly we work really hard to get people to as close as the life that they will live once they're not under the board in the year or so preceding that, so that we can have that transition and so that they're not transitioning out from under the board, as well as moving or, some folks want to do a no medication trial, in which case we would try and have them in a hospital to do that prior, right? Experiment with all of those things. But end of jurisdiction is very difficult for folks. And as a community provider, it's something that we're continually working on.
Yes, don't they receive a longer term under the board than they would have, the SRB board, than they would have if they were convicted? That's been my understanding, and I wanted to check it out.
Sure. The question was, don't our patients receive more time under us than they would if they were if they had been convicted? Generally, they stay under us longer than they would have stayed in prison. But the judge can put them under us for up to the maximum of whatever was indicated by the offense, and that is discretionary, but most often. Almost always, judges give the maximum. Yeah, so thank you. Okay, yes.
Yeah, they can proceed with the trial process once competency is restored. Well, I don't know the answer to that, generally speaking. But at that point, with proper treatment and their symptoms under control, they can understand and have a rational understanding of the trial proceedings. They can assist their attorney in their defense and also be an active participant in a trial. No, so what happens when the state hospital, for instance, determines a person is not restorable, does not meet criteria for involuntary treatment, then they have to discharge to jail because that's no longer appropriate to keep them at that state hospital level of care. Once they return to the jail, then it's to the attorneys to decide what to do. And either they initiate the cell lopes procedure, or what may happen is charges may not be pursued. If I'm told here, if the individual does not meet the cell or lopes criteria, then they're required to dismiss and release the individual.
Okay, and then here and here.
I was just gonna add, I've handled a few of those cases, and they have 3 years to restore them. If they're not restored after 3 years, the case is dismissed. Now there's a provision from the extremely dangerous person petition in which they can go under the PSRB, depending on what the crime was that they committed or were accused of committing.
That's correct, and I have a slide on that. We may not get to it, but that's okay because we're taking questions. Go ahead.
Quick question to the doctor. If the person is determined to be able to aid in their own defense, they understand their defense, but they're still deep-rooted in delusions, and they're released, how does that balance out? Because that's an issue.
Well, yes, that's certainly an issue. And as we know, a lot of mental health treatment is now being provided through jail and other correctional facilities. The number one provider of mental health services is LA County Jail. LA County Jail, and the second is Cook County Jail, which is in Chicago. So it's not a psychiatric hospital or facility, it's actually a jail facility that's providing more psychiatric treatment than any other facility in the country. So the issue arises if someone is released from jail for whatever reason, be it that they're incompetent and unlikely to be restored, and they still have symptoms. Well, in that instance, what do we do? Well, there are cracks in the system, of course, and that's a big one. However, getting people connected to other services such as housing, financial assistance, peer supports or support groups. Generally in these instances, people are not aware of their illness or their need for treatment. So my approach to that would be to engage them in some other way that would be supportive for their safe return to the community.
Yes.
Once they're restored, they can still make a GEI defense.
Yes. Once restored to competency, the person can mount a GEI defense. That's correct. Yes. Yeah, I think that's slide number 40 or something like that. Well, no, it's actually we'll make the slides available to you. To me, it is more important if you need to get information out of us standing here and especially out of our panel, then it's more important to me to get that handled than to necessarily go through the slides. My ego is not bruised by not getting through these slides. I promise. Okay. So, but yes. So I will go ahead and advance them though if there aren't any other questions for the moment. Okay. So this is a lot of this is what we've talked about, and this is one of the reasons I don't worry about getting through the slides necessarily, because a lot of times we cover them beforehand. But that's that public perception thing of getting away with something. And perhaps, in a situation in which a person is malingering, that's what they're after. That's what malingering is. But what we're talking about though is people with mental illness, and my experience of them, and I'll ask the panel, and they can feel free to contradict me, but these are individuals who are struggling a lot in just their day-to-day lives. They're not really getting away with anything. But holding them to putting them in prison for, again, going back to the person who kidnaps their kids because they have a delusion about their kids being in danger. That is not the same behavior as the person who's angry with their spouse, and so it seems that putting them in that same situation would not be effective when they have something that is treatable and should be treated. So this is when the red flags are for to sort of help us recognize, before if you're in court, something that may end up being a problem in terms of a GEI defense. So again, drugs and alcohol, paraphilia, that sort of thing. Those are the kinds of involuntary intoxication is a big one. Yes. Mm-hmm. Okay, so we have probably 20 minutes. Is that right? I'm not wearing a watch, so it's okay. So I'll get through kind of the sort of the rest of these really quickly. A lot of these we've talked about, but after the person has had the GEI finding, they're then placed under us. Okay, this is important. So the for any purpose piece of this will arise with respect to rental agreements, housing, that sort of thing, jobs. There are. If there's a situation in which in which someone is barred because from something for having had a conviction, GEI is not going to be that. Okay, so and if you have any questions about that, give us a call. It's a lengthier discussion, but just wanted to make sure that everybody knows that. Everyone under us has committed a felony, at least one felony. They can also have misdemeanor convictions, but if all they've done is a misdemeanor, then it comes down to whether the person presents a substantial danger, in which case they go to the hospital. Otherwise, they would be released by the court. And so this is we mentioned this before. The judge can either commit the person to the state hospital, or they can place them directly on conditional release. Once in the state hospital and under us, the board can also place them on conditional release. It's important to note that the hospital, if they believe that the person meets the criteria for conditional release, or for that matter discharge, they must ask for a hearing to get the person out on conditional release. It's an aerial shot of the state hospital. And this is kind of how people, generally speaking, kind of go through the hospital. The hospital has a risk review panel, and we like to see them. We like to see patients go to the risk review panel, with reasonable regularity to see, okay, are they ready for conditional release? Because if they don't need the hospital level of care, then that's not where they should be. For a variety of reasons, it's better for their treatment. Also, it is also more expensive to keep somebody in the hospital. Okay, so we had the day in the life question earlier. This is basically what it looks like. Katrina, feel free to correct anything on that if you want. But particularly somebody with a drug history, we might have more. We might do more UAs for people and then for people, as I mentioned before, with jobs they need to get to. Sometimes they're, if they've been stable for a while and they can show that they can handle driving, they get to drive, etc.
I would just add that, I don't think there's a typical day in the life of a PSRB client, and I think the reason for that is that the way that the board is structured and the way that conditional release is structured is really, really personalized. And so what a client under the board's day looks like depends on their treatment needs and on their goals, on their functioning level, on all these different factors that as their treatment team, we pay very close attention to. We have contact daily with these folks, and then we make recommendations to the board in terms of what the conditional release looks like.
Yes.
Unconditional release. What kind of support is given? Most of these people probably below poverty line. Housing and money. What's provided?
One of the nice things about being under the board is that there are additional resources for things that are needed for someone's treatment. And so we do have additional state funding that we use. Most of the clients that we have on unconditional release are in some level of supported housing. So in a community setting, that ranges anywhere from secure treatment, which is a locked treatment facility, to a residential treatment facility, which is the bulk of our folks. We also have semi-independent or intensive case management. There's all these different levels. We have clients that are unfunded entirely, that don't get SSI for a number of reasons, have no income. We're still able to obtain funding.
Well, paraphilia doesn't qualify, or but there may be a qualifying mental disorder that caused the sex offense.
And as far as substance use goes, many of our clients have co-occurring disorders. And so we do have a lot of folks that have struggled with substance abuse or substance use, and we certainly provide treatment for that. That just can't be what placed them under the board. Yeah.
I know we don't have a lot of time. I was wondering if you could speak at all on that kind of balance on the clinician side of being the mental health provider and also the, lack of a better term, PO, about meeting, that's my term, not yours, in terms of kind of making sure that they're meeting these 20 hours of supporting them while also having to, balance that. I was wondering if you could speak.
Absolutely. That's a great question. That's something that we talk about and think about all the time. And I think it is a balancing act all the time, right? Our primary responsibility is community safety. We also weigh extraordinarily heavily our responsibility to our client, providing treatment, allowing them to work towards goals that they identify, whether that's work or school or volunteering or relationships with their family. And so maintaining a therapeutic alliance with someone while also being their conditional release monitor and being the person that makes recommendations to the board, that could initiate a revocation process. So that would be somebody having their conditional release revoked and returning to the state hospital. It's a delicate balance. And I think what it boils down to in some ways is the belief that it would not be in someone's best interest to know that they were having an increase in symptoms and not do anything, or that they were becoming dangerous in some way and to not intervene or to not recommend a revocation. And so while that at times might put a strain on the immediate therapeutic alliance or the rapport that you have with someone, ultimately our clients are the ones that pay the price excuse me, if they're not meeting their conditions and they're not remaining safe in the community. So I think that ultimate belief that this system really does support people is how we grapple with that some of the time.
Can I just add? I want to add just something to that. Just from my experience in the program that we have, the vast majority of our clinicians are clinicians first and have no forensic, unfortunately at times, or criminal justice corrections experience before they come into that role. So for that reason, our focus has always been and primarily is, as a clinician, maintaining that therapeutic alliance while balancing that with the responsibilities under the board.
Question was about confidentiality, patient confidentiality.
Yeah, we certainly take patient confidentiality really seriously. We do abide by HIPAA laws. We have ongoing, excuse me, releases of information for the board. So information does flow freely between community providers and the PSRB.
I find it very interesting that you would say that you align yourselves with therapeutic values. Because the fact is that the PSRB only sees us 3 times a year, 5 times a year if we're out. The fact is that your group homes hold on to those people that cause the least amount of rift or problems in their homes. The fact is that your group homes can turn people down for no apparent reason. And it doesn't provide adequate treatment accessibility. It doesn't provide for the continuity of care. We're stuck at the state hospital. And we're given inappropriate care by people who supposedly have the knowledge or whatever to write chart notes. The chart notes are biased and based on, inadequate information often. And some are outright lies. But yet the PSRB accepts this as being okay. They take that. We have they tell us not to speak at our PSRB meetings. They tell us, a lot of the people that come in under GEIs are given false information. Oh, you'll be at the state hospital for 3 or 6 months. They're not being told the whole until the court date when they switch over to PSRB. So I find it very interesting and erroneous that you would provide flagrant lies to public individuals. I unfortunately am caught in your system. Yeah, people have said I'm ready to get out, but your board hasn't agreed. Your board has changed my diagnosis, something which your board shouldn't be doing.
The board doesn't make diagnoses, and I will acknowledge that not everybody's experience is the same, and some of our patients have more positive interactions with the board than others. Some of them it doesn't go as well. The board doesn't make diagnoses. The board listens to evidence, and they weigh evidence and decide what they think is more likely than not. That's the standard, is more likely than not. And so that's kind of how that works. And what is written is not always agreed with by the patient. That is absolutely true. So, well, I'm telling you the truth. Okay, well, that's something to discuss with your attorney and your case manager. So I need to move. Okay. Okay. Well, but that'll be a case manager discussion, et cetera.
That's interesting, because what you're saying is that as the board's weighing the evidence that's put before them, there's not set law that they're going by. They're exercising their discretion.
Within the law.
Well, sure.
There is set law. I mean, it's
Parameters, right? But this
right.
is really
That's what the law does.
exercising their discretion. And we kind of danced around that a little bit when we talked about, early release, or I'm just wondering if you could speak to that. You have 3 out of the 5, right, panel members.
Yes.
But it's a lottery of who you get. You could get somebody different the next time.
Sure.
Which would mean that the discretion is a little different, right? So I'm just wondering if you could speak to that a bit. Because I think this gentleman raises a good point.
I can talk about it. I'll talk about it. I appreciate both of you sharing that and framing. This is an important issue for community providers, for psychiatrists, for clinicians, for the board. Anyone who's under the board has faced this issue once, if not repeatedly, at any given hearing. So I've been fortunate in my role here to oversee the early discharge of probably 24 people in about 8 years. And there is a chance of that happening. A lot of it depends on the individual, and a lot of it depends on the treatment providers. In terms of the individual, the misconception that I have to be off medications or I have to have no diagnosis to get discharged is wrong. In my experience, the people that have been successful remain on medications and have established aftercare for their discharge. They also accept and have insight into the illness or illnesses that may be present. Of course, that is a therapeutic process that many times takes years to develop. In terms of the procedures that we go through to determine whether or not we're supportive of a full discharge include diagnostic clarification and risk assessment. If the individual is at a low level of care, has shown safety and safe integration into the community, they may be eligible for early discharge. We would either refer them if there's a need to for psychological and neuropsychological testing to clarify the diagnosis first. Secondly, we would do risk assessments before any hearing, and that includes doing a START, doing other violence risk assessments to determine whether or not that person represents a substantial danger in the future. Taking all that information together, we go to hearings, and we present the information to the board that we have and an opinion whether or not we support the request for full discharge. The decision is ultimately up to the board. What we do is we provide all the information we can and let the board make their decision. If the decision is not favorable to the client, they have a right to appeal. They actually have a right to appeal to the criminal court system and the appellate court system. That's how it's done.
He's not talking about early discharge. He's talking about getting out of the stage.
Yeah, and so and that's great, and it certainly you know, I appreciate what you shared, and I know that we frequently run into people who feel like they didn't understand what they were signing up for, and that can be really challenging. I will say that one thing that I like about the board is that the spectrum of possibility is really wide, right? From being anywhere from in the hospital to living independently, working full time. But it is a long, very bureaucratic process, and that can be very discouraging and very frustrating. And I think we can all attest to that. So for a conditional release hearing, and I, you know, I don't know the specifics of what you were speaking to in your experience, but as far as the subjectivity piece goes, the treatment team and the client, prior to any hearing, whether it's an administrative hearing to request a reduction in UAs, all the way up to a discharge hearing, are working to complete assessments, put together documentation, provide a clinical opinion to the board. So even for conditional release, the treatment team and the client all weigh in very heavily in terms of recommendations, progress, risks, ways to mitigate risks. And so it's the board makes the ultimate decision, but we testify at those hearings. We provide pages and pages and pages of clinical documentation and all of that as well.
And,
But on exhibits that we don't know what's on those papers. We don't see those exhibits.
well,
We only
that's
have the numbers.
but that's something that you can discuss with your attorney. It's not the board keeping you from seeing that.
Well, considering
So
that Harris works with like 600 people,
he.
I don't think Harris has the time
Well, but that's not the board telling you you can't look at it, though. It's not that you cannot look at it. And so, and I noticed also that it is 11:30. I know I'm happy to hang around and answer more questions. And if the panel is able to also, that would be great. Feel free to come on up. So thank you very much.